James Comey case dismissed. What to make of this headline and what actually happens next? Quite a few attacks on the Comey indictment. Which of them is the one that worked? And what does it mean that the judge is dismissing the case without prejudice? That means it could be brought back again. Will it be brought back again? Lots of questions here, and we have answers. But first, hit that subscribe button. Get us to the 1 million mark because we're real close. Make us the biggest and the best. Now, this happened as the judge said Lindsay Halligan, the former Trump beauty contestant finalist, who's now the interim U.S. attorney in the Eastern District of Virginia, was not really a valid U.S. attorney, that she was illegitimately appointed. Now, I've been covering the whole Comey indictment debacle in a whole series, and in the last one, focused on the kind of big summary motion to dismiss by the Comey team filed in the Eastern District of Virginia, where his defense team summed up 3 relevant motions, all before different judges, actually a couple different judges here. First, motion to dismiss for unlawful appointment. Second, motion for implementation of a filter protocol, meaning there's evidence that was tainted, needed to be filtered out, that was shown to the grand jury. And third, a motion to dismiss for vindictive and selective prosecution. It's the first one which is not in the Eastern District of Virginia, because it's presumed that an EDVA judge might have conflicts over whether the EDVA U.S. attorney was validly appointed, so it's with a different judge altogether. But it's in that inquiry, with the different judge, different district, South Carolina, where really all the issues commenced, because that judge asked for an in-camera review of the grand jury transcripts, discovered the missing 2 hours of them, leading to a question later in the hearing about the sequence of events, which Halligan claimed no transcript because nothing happened. Judge said, doesn't make any sense in terms of the timeline, that nothing happened, something had to have happened. But in any event, after all that, which gave rise to a whole bunch of different issues, that is the case where the judge was considering whether or not Halligan was a validly appointed U.S. attorney. That decision has tanked the Trump's DOJ prosecution of former FBI Director James Comey. The judge is Cameron Curry in the U.S. District Court for South Carolina, Clinton appointee. It's in South Carolina because the EDVA judges presumed that they would have a conflict deciding whether the U.S. attorney that they work with, different branch of government, might be invalid. Eastern District of Virginia is in Alexandria, just outside D.C. They recused over this. Now, that's an example of caring about conflicts of interest that in the Trump DOJ era, we've all practically forgotten about it. But that was a recusal based on a concern over a conflict of interest there. The other 2 motions attacking the indictment are in EDVA, but it's this resolution, the first one, that temporarily kind of moots those. What did Judge Curry decide? Let's take a look at the analysis. The analysis references some complex statutes and the Constitution by which interim appointments can be made, as well as the constitutional process of presidential appointments that need to be confirmed by the Senate. But it really boils down to something pretty succinct. Congress established a method for appointing interim U.S. attorneys when there's a vacancy. That's 28 U.S.C. Section 546. And what that says is that the Attorney General can appoint a U.S. attorney for the district if it's vacant, and they can't appoint someone who the Senate already said, no, we don't like you. And that person can serve until one or the other. Either there's a qualification of a U.S. attorney for the district appointed by the president and confirmed, or the expiration of 120 days. So the interim can serve for 120 days as an interim. If that 120 days passes, then it goes to the courts. The district courts can appoint a U.S. attorney to serve until the vacancy gets filled. So here's what happened. The original interim U.S. attorney was a lawyer named Eric Siebert. His 120 days were going to expire May 21st, 2025, but May 9th, the district court judges stepped in and appointed him to continue so that they wouldn't have a problem with his term expiring. But on September 19th, Siebert quit, according to reporting, because he didn't like the idea he was being forced to bring bad cases against Comey and James, so he quit. Trump then did this famous public post where he publicly was shaming Attorney General Pam Bondi. Why hasn't she indicted all of his enemies like Comey, Adam Schiff, A.G. James? 48 hours later, A.G. Bondi appoints Halligan to be the interim U.S. attorney, September 22nd. September 25th, she gets the Comey indictment, with only a few days to go before the statute of limitations runs out. Here is the issue. Section 546 only speaks to one interim appointment by the Attorney General, after which it goes to the courts. Bondi used up her one appointment with Eric Siebert, who seems to have quit in protest over being asked to bring this case. Instead, Trump's DOJ, Bondi at the head of it, insists it's okay. She can keep naming interim appointments. She's not limited to just one. Now, normally this is really a non-issue because it really doesn't happen very much. You might have an interim appointment and then somebody gets nominated and confirmed by the Senate. Keep in mind, Trump at this point has only 2 Senate-confirmed U.S. attorneys. Everyone else is interim. So it's a big issue with the Trump administration liking to do this. And the clock is running on those folks, or in some cases, they've already expired. Alina Habba also was found to be serving invalidly. So, as Judge Curry is pointing out, allowing this never-ending series of interim appointments means that the Trump administration really just gets rid of the congressional role altogether. The advice and consent of the Senate, eradicated. Don't need them for U.S. attorneys. We'll just keep doing interim ones. So, Judge Curry held the line, not on a technicality, but something really basic to the Constitution, which is the president appoints, the Senate has to give consent and advise. Trump's gotten rid of that. Judge Curry said, nope, the appointment's illegal. She lacked any authority to bring the Comey and James cases, no different than someone walking in off the street bringing the charges. Add to this that Halligan was completely solo on this first shot of hers in any criminal case whatsoever. So there's no argument that some other federal prosecutor was even involved. That was good enough. All her. She took the shot all by herself. That proved fatal to this case. Trump, DOJ, Attorney General Bondi, of course, have attacked the judge already, says they'll appeal it, and Bondi said Halligan is a fine attorney. Yeah, that's a useless point. Maybe Halligan is a fine attorney, but she was not the U.S. attorney. That's the problem. She can't bring criminal cases. Which brings us to what's next. Besides the appeal, and of course the Trump regime will beg the Supreme Court to get involved, Judge Curry dismissed the case without prejudice, which means that she says she was putting Comey in the same position he was in before the indictment. But putting Comey in the same position doesn't mean that the United States, the Trump DOJ, is in the same position. While normally a dismissed indictment gets a do-over, this is not really a dismissed indictment in the normal sense of the word. As Judge Curry put it in a footnote, which has sort of been overlooked by a lot of commentators, the judge addressed this point, which is the return of an indictment tolls the statute of limitations, right? That's the problem for Comey and DOJ. Well, not for Comey, for DOJ. That Comey statute was running. It's already run now. Normally, it tolls that statute. But the invalid indictment itself can't serve to block the door of limitations as it swings closed. Meaning, if the indictment wasn't valid at all, it can't serve that function. So the idea of insulating this case from any statute of limitations problem by simply refiling is a problem because the indictment's void. It's not like there's something wrong with it. There's some procedural issue. We dismissed it. They get a do-over because they tried to start it on time. The judge's footnote says quite clearly, this is not that. It was a void indictment. You don't get to do a do-over. So even though the judge is saying it's without prejudice, it doesn't need to do it with prejudice. There's going to be a legal obstacle to bring it back again. So that's another hurdle for the Trump DOJ. Once they get through trying to argue that Halligan actually is validly appointed, if they lose those appeals, then they'll probably try to re-indict, at which point they'll then run into the statute of limitations problem. After that, there's more. There's actually more than that because remember these other motions to dismiss based on vindictive and selective prosecution, they're still out there. They're kind of moot for now because the case is gone. But if the case revives somehow, those arguments remain to be decided and they remain strong. So it's a really long slog for the Trump DOJ on this case coming up, and we'll be happy to keep an eye on it for you.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.